Welcome to another edition of the Litigation Psychology podcast, brought to you by Courtroom Sciences. Today, broadcasting live from West Palm Beach, Florida, in my hotel room. Good to be on the road. Very special guest today, Eric Miersma. And Eric, you're over in San Diego, correct?
I am. I don't know how that compares to West Palm Beach, but we seem to have picked a couple nice spots.
Perfect. Beach. So we're going beach to beach kind of here. Eric, I read your bio and I found it fascinating. Can you tell us about what you did before you were an attorney and how that helps you be an attorney today in the industries that you work in?
Well, I did a lot of stuff to get through school, but I think the thing that I probably had the most fun doing and what most informs me now is I was a licensed OTR driver. I worked for a couple different companies, and I spent some time driving and got to see a lot of the country, met a lot of people, and learned a lot about the lifestyle and the rules and just what it's like to be out there. And I think that really helps me relate to my clients, especially the drivers. I mean, I have a little bit of an insight into what these poor guys have to go through day to day.
Wow. That's really, really incredible. I don't want to hear about the truck stop stories. We're gonna leave those out of this particular podcast, if that's okay.
Good.
That's okay.
Excellent. And I'll pretend that my logbooks were always in perfect order as well.
Yes, of course. Yes, of course. Now, do you also do some construction litigation?
I do. Yes, I cut my teeth doing construction litigation in Southern California, and all the tract home developments out here and big condo buildings downtown, and that really taught me a lot about indemnity and risk management, risk transfer, complex litigation. And I find that those skills really transfer well to trucking litigation with multiple parties and lots of interesting, lease arrangements and so on.
That's incredible. Great experiences to, of course, bring into law. How would you compare and contrast those two areas of litigation? Because I'm sure they both have their unique headaches, right?
They really do. And what I've found in construction is you're often blessed to be working with very sophisticated clients who have a lot of experience in the industry, of course, but then also with litigation. I mean, it's a accepted fact of life in Southern California and probably in most places. If you build something, you might get sued for it. And they've learned the hard way over the years how to manage those risks, either through their contracts up front or during the litigation. They have people who are experienced at giving deposition, who are experienced at producing documents. Now, when I get into the trucking arena, what I see is me in particular, I work with a lot of smaller operators, a lot of smaller companies. And for most of them, this may be the first time they've ever been sued. They have zero litigation experience. And we can kind of get into that a little bit, I think, but these guys are really struggling to understand just what's happening to them. They're at a completely different level. And so I find myself having to do a lot more education with the trucking companies, and hopefully it pays off for them.
Yeah, that's an excellent point. Before we go any further, tell us about the firm. Tell us about the types of cases that you handle, and maybe a little bit of background on the law firm.
Yeah, sure. I'm a member at Balestreri Potocki Holmes, and we're a boutique law firm that just do a little bit of everything. We specialize in general civil litigation, construction, transportation, employment. We do some auto dealership law, as well as get into some premises liability, and we even work with draft beer and cannabis companies in San Diego. So we've been continuously expanding our business and trying to, like the rest of the world during COVID, adapt and move on. Yeah, I've worked at this firm now since I was a law clerk, since way back in the day. We won't say when that was.
You don't want to age yourself, Eric? I mean, come on.
So I don't know, it's a lot of the people have been with us a long time, and I think that says a lot about our collegiality and the work environment, and it also helps us build a really professional set of goals and standards when we represent our clients.
That's outstanding. Now, you and I have done a podcast before for DRI, and I think that was a great series of podcasts. And something that always comes up, whether it's construction litigation, whether it is transportation litigation, is the deep importance of effective witness performance, both at deposition and trial. And now that you have, a very active plaintiff's bar that's using a lot of reptile tactics, tell me how you approach when you work with your witnesses and what you know that you need to accomplish. Because as we both know, if witnesses don't perform well, that could lead to very, very bad things, meaning nuclear verdicts and or nuclear settlements.
It is. Kind of the first rule of getting ready for a witness's deposition, or just in general dealing with your client, is to avoid surprises. I find that the very first thing I do that gets me the best information is maybe this is obvious, is getting a hold of your client, your driver or the safety officer or whoever is in charge at the motor carrier, and just talking to them and interviewing them, getting as much information from you and trying to build that rapport so they trust you, and you in turn can trust them a little bit, that they're not holding something back or there's some skeleton in their closet. And what I find, we touched on this earlier, is I deal with everything from companies who have professional witnesses. These folks are big operators. They've got people in-house that are always produced as the person most knowledgeable or the person most qualified. Some of these people are trained to the nth degree. They do mock trials. They have lawyers, prep them endlessly just for practice. And you really know what to expect, and they really know the company, and they know how to respond to reptile tactics. At the other end of the extreme, where I'm usually find myself, is dealing with witnesses who've got no experience whatsoever, and there may even be a language barrier as well. And when you're having to deal with that, I spend a lot of time just trying to educate them, trying to teach them what a deposition is, or I can't even get into the nuances of reptile theory. I just have to make sure they pronounce their name correctly. And it's that, I think. So my biggest concern with those witnesses is to just go over and over their story with them, or their version of events, and try to get all the facts, try to explain to them why some of this stuff is important, why it's important that they don't say things like, yeah, of course, my goal is always to be the safest driver on the road, or something like that. And it clicks. They're smart people, but they're just inexperienced. And so if you can show them, the plaintiff is going to ask this question, and here's why it's really important, and you kind of have to take them down that road. So it's a lot more time intensive. You have to spend a lot more time with them. And frankly, that's even hampered by the cases that are involved. If you've got some small little case, man, your carrier or whoever's paying your bills is not going to want to see you run up hours and hours and hours of witness prep time. So that can be a challenge too. But I definitely, you see the results pay off when you see the light go on in your witness's eyes. They get it, and now you've given them the tool to handle those curveballs in deposition, where you can't possibly prepare them for everything that's going to happen. You can just try and teach them what to do if it does happen.
Yeah, I think witness training and preparation, I provide more of the psychological, emotional, cognitive, behavioral training. I think it's really worth every penny, because it can really save millions on the back end, and it helps your client, and it definitely helps someone like a driver. How do you deal with this very sensitive topic of witness preparation of a witness that has been terminated, and now they're a foreignborn?
Wow,
Very
very carefully, exactly, and it depends. The other good lawyer answer. I actually have a case where I'm dealing with that right now. The driver quit about a week after the accident, never told his boss the accident had even happened, and months later they got sued. And the owner's like, "What happened? I have no idea. First I've ever heard of this." So I guess the biggest issue for me in dealing with the witness who's no longer an employee is why did they leave? Were they on good terms or bad terms? Were they fired? sometimes people just move on, or maybe they get laid off because there wasn't enough business, enough work for them. I want to find that out as early as possible. Um, Sometimes the witness, the driver or the employee, can be a better witness for you than the actual employer. Um, they just don't know what happened, or they don't care, or there's all types out there. So my first goal is always just to get as much information on the front side as possible, and try to make that former employee understand why he should care about this at all.
Which is often difficult, to try to motivate them.
Well, I could probably use you, Bill, in that respect. I mean, that's the psychological aspect is, how do you get these people to be motivated?
Yeah, and I say like this is your name on the line. I mean, especially if they didn't do anything wrong, or it's very limited liability, to say, why are you going to let this plaintiff attorney do? They're going to drag your name through the mud at trial, right? I mean, let's not let this happen, and then show that even though they're not an employee anymore, that you're there to provide the emotional support, particularly to them, because litigation is a very stressful process, and I think all witnesses need that type of support. Now, everybody knows about the driver shortage. This has increased the percentage consistently of foreign-born drivers. So let's throw another wrinkle into witness preparation. When you have both language and oftentimes a cultural barrier, in my experience, talk about taking baby steps. I mean, it's a very slow process with the foreign-born witness, and oftentimes they come in with a lot of illogical fears and anxieties because it's a cultural issue, and maybe they're scared of the American legal system. How much are you seeing of that in the industry?
A lot. Oh, an awful lot. I would, and it particularly affects me here in San Diego because we are obviously next to an international border. So I deal with a lot of cross-border traffic. I deal with a lot of drivers who were born and raised in Mexico and may even still live across the border, but across the border to drive over here and work here, and often we have the Spanish that's spoken in Southern California is a unique language all to itself, and so there's a lot of different terminology and words that don't easily translate. So I have a very large roster of interpreters that I work with, and I also work with a lot of Iraqis, a lot of Persian drivers, and it comes back to trying to understand and meet your client. That first phone call is so important. You try to figure out who they are. You learn about their experience. I see some people that are working here that were very successful business people in another country, and they've come to this country, and maybe at one point they were, they owned their own construction company, or maybe their own trucking company, or were doctors or lawyers or whatever, and they find themselves in the US, and trucking jobs, because there is a shortage, they can get those jobs and they can get hired and try to get their feet on the ground. But they're very smart, very educated people. And so working with them, once you explain the legal system and how it works to them, they're usually quite easy to work with. They grasp the concepts quickly. The flip side of that coin is I get folks who find themselves in a driver's seat who have very little education, have very little understanding or sophistication about the legal system, and it is a huge uphill battle. And at some point, all you can do is try to just the truth will set you free. Just tell me what happened and don't say anything else ever.
Shut up. Let's switch gears a little bit to construction litigation. My experience with that, which is very different than transportation, is that there's typically multiple defendants, contractors, subcontractors, owners, and the finger pointing that goes on is absolutely incredible in construction litigation. What is your approach when you're working up a file and you pretty much know three other parties are probably going to be pointing at you?
Yeah, construction, that's the name of the game, right? I mean, we've represented a ton of general contractors and developers over the years, And that is always, you're the biggest target, and you also have hopefully the best contracts. So first thing you're doing is you're like, who else can I bring into this mess? What subcontractors can I do? Are there design issues that, need to be dealt with and brought in? And, you throw in different types of insurance. Maybe there's OSIP policies or RAP policies, and you're going to get countersued, or you're going to have to defend the whole mess. So you're really looking around carefully. And if you're a subcontractor, you're always looking for, who else is going to counterclaim against me? Maybe I'm a framer, and so now there's going to be all kinds of issues that they're going to come after me. The drywall guy is going to sue me because there's cracks in his drywall, and he's going to blame my framing because it's crooked or something like that, or moved. In trucking, it's a little different. When you come into trucking and you're looking around for who there could be for multiple defendants or co-defendants, you get some interesting situations. I mean, there's the obvious, maybe the shipper or the broker or somebody like that. But not always so obvious are, when there are joint ventures, or there are other, maybe there's other drivers even. Maybe there was a team driver or something that somehow got involved with this. Maybe there's you get these unique arrangements with owner operators and who they're leasing their equipment to, and who's actually providing their paycheck or their insurance or doing the maintenance on it. We all know all these different entities, and you got to really start to figure out, in those cases, honestly, I like to work with the experts early on. Tell me, is there a mechanical problem with this that contributed to the accident? Should I be looking for the maintenance guys to see what happened? Or, if I'm looking at the lease agreement and I see some really complex language going back, and I find out that the person who owns the truck has nothing to do with the driver or the motor carrier or the dispatcher, all kinds of questions start to come up. So you got to do that early investigation and research. And if you have the luxury of time before you have to respond to your complaint and get that cross complaint on file, you can try to do a little of that. But sometimes you got to shoot in the dark and just stick that cross complaint out there with a bunch of does and hope for the best.
Hey, all is fair in love and war. Oh man. Let's bring up a very difficult topic, because I've been getting a lot of phone calls on this. Cases in which you're admitting liability. Probably never the place you want to be, right? Particularly for trial preparation. What is your philosophy? Because no one agrees on this. No one agrees on it. I'm a big fan of counter anchoring, really attacking the plaintiff's completely inflated numbers as early as possible, and early and often at trial. But then the type of tone that you take, you're skating on thin ice when you're admitting liability, right?
Yeah, you really are. It's a kind of a double-edged sword. On the one hand, at least in California, you do get some benefits from admitting liability. You can try to take the motor carrier out of the picture and get rid of those negligent entrustment, negligent hiring. The motor carrier's record. If you've got a real fly-by-night operator and the driver is clearly at fault for this, it might be the best thing to admit liability and just get that whole mess out of the way. In other circumstances, it's, the jury's going to want to know, why are we only talking about damages here? And even if nothing comes in, no evidence about liability, or, that type of thing, you still have that unanswered question, and that can almost be worse than just fighting about it in court. But I think if you take the approach, and I think you have to, maybe you can tell me what you've heard and that's different than this, but once you've admitted liability, you've pretty much committed yourself to telling the jury that, look, this was an accident. It happened. Bad things happen to good people. There's, through no fault of their own, but, they're trying to take advantage here. This isn't, yeah, we rear-ended them, but we were going 1.5 miles, and our expert says there's no way this required spinal surgery. So, you do what you got to do.
Yeah, and I think putting the plaintiff attorney on trial is often highly effective. Showing a lot of sympathy to the plaintiff, but really putting that number to say, listen, this is not the California State Lottery, ladies and gentlemen. This is an accident, and remind the jurors that their job is to be fair and to be reasonable. I had a case down there with Liz Skane, who is a local attorney down there, and we were in a really, really bad case, and we were liable. and we admitted liability. And I helped Liz construct her opening statement. She said the words fair and reasonable 18 times.
That's a good strategy, actually.
Yeah.
One of the things I always do, yeah, when I depose the plaintiff, I always ask them, who's paying your medical bills?
Yeah.
What treatment did you get? Who paid for that? Did you get a bill? Yeah, I mean, and they often just, I don't know why they're not more prepared for that question. You'd think it's obvious, but they always kind of have a blank look on their face. Well, I don't know. Well, how are you going to pay for it? I don't know. You going to pay for it for this lawsuit? I guess. And
That's
it,
incredible.
yeah.
Incredible. Let's wrap this up here and hit kind of an obvious topic is the impact on COVID. Well, I think you have three things going. I've been telling everybody this because we've been doing a lot of jury research. Everybody's like calling me, like, well, what has COVID done to the jury pool? What has it done to the witnesses, right? But there's two other things going on. The highest level of social unrest in the history of America, even worse than 1968, in my opinion. And the political tension, right? So you have the George Floyd effect, you have the Trump election effect, then you have COVID. Talk about you. I mean, that's like a perfect storm right there. And it's I know in our jury research, what we've seen is people aren't being nice to each other per se. They're a lot. I think I've seen a lot more emotion from jurors. People have completely stopped listening to each other, and a lot of that happened pre all this stuff. But I think I've seen that get worse. What are you and your firm doing to try to put your heads together so then things start opening up? You're back in courtrooms to make sure that you're adjusting appropriately. Because I know the plaintiffs bar, they're salivating over this opportunity coming up, and they think they're going for blood. They are.
Yeah, it's kind of like a big pile of dry wood soaked in gasoline, just waiting for the right match to come along.
Yeah.
It's you want to think that politics don't intrude into a trial, that it's all objective and fact-based, and everybody's just going to tell their story, and you're going to have a perfect jury that's going to put aside their personal biases and follow the law. And of course, we all know that never happens. So, personally and in the firm, what I see is depending on the size of the case, if it's a big enough case, you're going to get a jury consultant in there, and they're going to really work with you. I've even done this with cases in real time. I've had some really good juror, as the jurors' names are being announced, somebody, is texting them back, and they've got a team there who's running their social media accounts and figuring out who they are and what they're all about, and try to develop, who has these internal biases and what you can do about it. The reality is my approach to jury selection is always you try to weed out the worst of the bunch. You hope, and you can't do that based on a lot of these political and social media type things, but what you can do is try to understand their viewpoint. How do they approach life? How are they likely to see your client? And you really have to know your client and your company. How are they going to be perceived? Is this a guy who's got face tattoos in a truck with a big chrome jaws over the grill? How's he going to be perceived by a jury? First, is he, a 60-year-old Spanish gentleman and a grandfather who's been a truck driver for 40 years and never had an accident, and has got 25 grandkids? That might be a whole different kind of defendant that you want to put on there. I don't worry too much about the political point, but I do worry about the COVID aspect of this, as it affects everybody's willingness to be there. Yep. Do they really want to hear a bunch of people fighting over a pot of money when the whole world is burning and people are just trying to get by? They may not.
Or they're sitting at home collecting their stimulus checks and they're not working. I mean, it kind of cuts both ways, doesn't it?
Yeah, absolutely. And we get a lot of we're a military town, and we've got a lot of biotech out here. We get an interesting jury pool. They tend to be, relatively conservative, I think, and you also tend to get fairly educated jurors, not just retirees, but it's funny you mentioned, sitting at home collecting stimulus checks. The stimulus checks has nothing to do with this thought, but the idea, I've had people on the jury who were software developers and game programmers, and they literally sat at home on their laptop all day, and they were incredibly smart, very educated, but they could take all the time in the world and were totally intellectually curious about being on a jury. And that can just throw you for a loop sometimes. You don't know how these people are how to decide.
I know that we've got a lot of work to do, but Eric, thank you so much for being on our podcast. I would love to work with you in the very near future, so keep in touch. And I'm sure we will be keeping in touch as we start to learn more about jury behavior as we are really cranking towards 2022 at a pretty good clip here.
Yes, thank you, Bill. I really appreciate it. And yeah, your services are just worth their weight in gold. Yeah, well, 2022, state courts out here, I've gone and asked for a 6-month trial continuance and got it stuck out 18 months without any asking from me. So
a lot of work around the corner. Eric, thank you. And to our audience, thank you so much again for participating in the Litigation Psychology podcast brought to you by Courtroom Sciences. We'll see you next time.
Thanks a lot, Bill.